Okay. Good morning, assalamu alaikum, and welcome everyone to today's webinar, Long Before Nuremberg, Islamic Law of Armed Conflict, sponsored by Anathem Global in cooperation with the International Bar Association's War Crimes Committee. I'd also like to thank Sorry about that, a bit of a technical. I'd also like to thank ASIL's Labor Society, the ICRC, and others who promoted this event to their membership. We are thrilled to have such an incredible and diverse global interest in today's program, attendees via Zoom, as well as via the live cast on YouTube today. For those of you observing, Ramadan Kareem, and may you continue to have good health during the Eid holidays. Please note that this webinar is being recorded and live streamed online. If you do not consent to this, kindly leave the webinar at this time. My name's Sarah Elizabeth Dill, and I'm an international law attorney at Anathem Global, splitting my time between Washington, D.C. and the Middle East and Gulf region. I currently serve as the Arab Region Liaison Officer for the IBA's War Crimes Committee, and this webinar is part of a series that we started pre-COVID, focusing on international criminal law and humanitarian law issues in the MENA and Gulf regions. The International Bar Association's War Crimes Committee is currently chaired by two phenomenal attorneys, Natalie von Wustenhausen and Stephen Powells, and they focus specifically on atrocity crimes and international criminal law and practice. The committee endeavors to provide its members with comprehensive and reliable information and resources on international criminal law, working alongside the IBA Human Rights Institute and the IBA Human Rights Law Committee. Since 2017, our committee also has a connection with the International Committee of the Red Cross, and we are fortunate to have one of their experts here with us today. Our committee hosts an annual conference each spring in Den Haag, and we'll be hosting a number of webinars over the next months. I hope that you will join our committee for these continued webinars, and inshallah, we can all meet in person in Den Haag again in 2021. We are fortunate to have three absolutely incredible experts with us today. You should have received their impressive bios via email, and I will just give brief introductions now so as to preserve our limited time for their presentations and your questions. Dr. Asma Afsaruddin is the Professor of Islamic Studies and former chair of the Department of Near Eastern Languages and Cultures in the Hamilton Lugar School of Global and International Studies at Indiana University in Bloomington. She's the author and editor of 9 books, including her forthcoming book, Jihad, What Everyone Needs to Know. She is also currently the chair of the board of directors of the Center for the Study of Islam in Democracy in Washington, D.C. Dr. Ahmed Al-Dawoodi was born in Egypt and is the legal advisor for Islamic law and jurisprudence at the ICRC. He also teaches a course on Islamic law of armed conflict at the Geneva Academy of International Humanitarian Law and Human Rights in Switzerland. Dr. Al-Dawoodi is frequently published on Islamic law and the author of a wonderful book, The Islamic Law of War. Finally, Dr. Corinne Zoli is the Director of Sponsored Research and an Associate Teaching Professor in International Security and Director of Research of Security Policy and Law at the Syracuse University College of Law and the Maxwell School of Citizenship and Public Affairs. Dr. Zoli's research focuses on contemporary problems of warfare from a cross-cultural and interdisciplinary law and policy perspective. She has multiple publications, including her poignant article, The God Gap in International Humanitarian Law. Our format today is that each speaker will provide an 8 to 9 minute presentation, followed by a question and answer session. Please use the Q&A function at the bottom of your screen, and we will do our best to get as many questions as possible. Many scholars will often speak of Nuremberg as the first instance of prosecutions for war crimes, and the Rome Statute and International Criminal Court marked the beginning of a permanent set of laws to govern crimes committed during armed conflict. But this is not necessarily the case. Throughout history, many groups have adopted norms or rules for armed conflict. The Greeks, the Chinese, ancient India, Native American populations in North America, and even the Old Testament contains references. Islamic law, or Sharia law, has long contained provisions governing conduct during hostilities, targeting, protection of civilians, treatment of prisoners of war, and even post-conflict justice and reconciliation. Islamic law developed during a time when tribes and young nations were at war with one another. Many of the provisions are similar to, if not at times more humane, than those contained within the Rome Statute or Geneva Conventions. Unfortunately, this rich body of law has gone largely ignored or unknown by Western scholars and experts until recent years. Few global discussions about post-conflict justice in Muslim-majority countries include discussions of Islamic law, despite the fact that many of these nations have a system of laws governed, at least in part, by Islamic law. Our goal today is to provide an introduction to this topic and, based on the extraordinary response we received, host more specific and advanced webinars in the future. As our world shrinks, borders become less impenetrable, and we evolve into a more blended society, it is important for all to be knowledgeable and understanding of the beliefs, values, laws, and moral guideposts that govern actions of a particular race, ethnic group, culture, or religion. This is especially true in the legal profession, and even more important when examining conflicts and developing strategies for lasting peace. Thankfully, today we have 3 experts who will guide us in that process. So without further delay, Dr. Asarudin, congratulations again on your upcoming book. Help us dive into this topic, and please discuss the notions of war and peace in Islam and why this is such a vital part of daily life for Muslims, and why examining Islamic law should be a necessary part of any discussion of conflict justice.
Well, thank you very much. First of all, Sarah, for this invitation to take part in the webinar. And good morning or good afternoon, as the case may be, to all of our participants. So Islamic perspectives on war and peace are actually quite old. They go back all the way to the 7th century of the Common Era, when the religion of Islam came into being. The Quran, which as Muslims believe was revealed by God to the Prophet Muhammad in the 7th century in Mecca in the Arabian Peninsula, has quite a bit to say about war and peace and how they should be regulated in the world. Whenever we talk about armed conflict in the Islamic milieu, we immediately think about the word jihad. And I should point out that the word jihad in itself does not mean fighting or war. It is a broad term that should be translated into English as struggle, striving, effort. The specific Arabic word for fighting as used in the Quran is qital. However, since jihad has become the common word to refer to armed combat, I will also use it, but with the adjective military, so that I will be referring to the military jihad specifically in order to distinguish it from other forms of non-combative jihad. The military jihad was proclaimed during what is known as the Medinan period of Prophet Muhammad's life. The Medinan period started with the famous Hijrah, or emigration to Medina from Mecca in 622 of the Common Era, which is also the first year of the Islamic calendar. It was in Medina that Muslims were finally allowed to resort to armed combat to defend themselves against the pagan Arabs who had persecuted them in Mecca for proclaiming their belief in one God. In the Medinan revelations, the Quran provides specific just causes for which recourse to lethal force may be sanctioned. Roughly 2 years after the emigration to Medina in 624 of the Common Era, 2 Quranic verses from chapter 22, verses 39 through 40, that allowed Muslims to fight in self-defense were revealed. These 2 verses provide explicit reasons for engaging in the military jihad. First, the initiation of fighting by the enemy, in this case the pagan Meccans. Second, the wrongful expulsion of people, that is the Meccan Muslims, from their homes. And third, for self-defense against the violent persecution that Muslims had been subjected to for no reason other than their affirmation of belief in one God. Similar reasons which legitimate an armed response to the adversary are contained in another important group of verses found in chapter 9, verses 12 through 13. These verses stress that the violation of pacts by the pagan Meccans and their initial act of aggression against Muslims had made fighting necessary against them. Therefore, when both just cause and right intention exist, fighting in self-defense against an intractable enemy may become obligatory, as stated in chapter 2, verse 216. The Quran further states that it is the duty of Muslims to defend those who are oppressed and who call out to them for help, except against the people with whom the Muslims have concluded a treaty. The Quran also has specific injunctions with regard to initiation of hostilities and conduct during war. chapter 2, verse 190 in the Quran states, "Fight in the cause of God those who fight you, but do not commit aggression, for God loves not aggressors." End of quote. This verse specifically forbids Muslims from starting hostilities. Fighting can only be undertaken in response to a prior act of aggression by the opposite side. Proportionality is also explicitly stressed in the Quran in chapter 2, verse 194, which states, "Whoever attacks you, attack him to the extent of his attack." Two significant verses from chapter 60, verses 8 through 9, mandate kind and just interactions with those who are peaceful, regardless of their religious beliefs, in contrast to those who willfully commit aggression. Another important verse, Quran 8:61, which I like to call the quintessential peace verse, requires Muslims to stop fighting as soon as the other side ceases to fight and makes peaceful overtures. There are two other verses that are often cited in the literature that have been understood by some scholars and jurists, by no means all, to promote the view that fighting in the Quran is not only defensive, but offensive as well. The first is chapter 9, verse 5, which has been understood by some to mandate fighting against all non-Abrahamic non-Muslims until they convert. And the second is from chapter 9, verse 29, that is understood by some to require fighting against the people of the book, that is to say Jews and Christians, until they either submit to Muslim rule or embrace Islam. These interpretations are highly problematic because the verses I already cited, Quran 22, 39 through 40, chapter 2, verse 190, chapter 60, verses 7 through 9, and 861 in particular, together clearly establish that fighting was contingent on the prior aggression of a hostile enemy, and that peaceful people, regardless of their religion, cannot be attacked under any circumstance. Typically, classical commentators on the Quran restricted the applicability of chapter 9, verse 5 to the Arab polytheists of the 7th century who had resorted to violence against the early Muslims. Similarly, with chapter 9, verse 29, early scholars understood this verse to refer to only the Byzantine Christians during the 7th century who had displayed hostility towards the Prophet and his followers, and therefore could not be generalized to all Jews and Christians. If we turn to the Hadith and legal literature, the concept of jus in bello, or just conduct during warfare, becomes very prominent. These hadiths are the sayings of the Prophet Muhammad, as well as the sayings of his companions, his close associates, are frequently repeated in the legal literature. So, for example, the well-known 8th century jurist Malik ibn Anas quoted a report from Abu Bakr, the first caliph, in which he famously prohibits attacking different groups of civilians, forbids the burning of fruit-bearing trees, and the unnecessary killing of animals. To the list of women and children who enjoy non-combatant status are added the elderly, the blind, and the chronically ill in general, and non-combatant men such as serfs and slaves, as well as hermits and monks whose dwelling places cannot be attacked. Also, a legitimate military jihad can only be proclaimed by the recognized ruler of the Muslim polity, the caliph or the sultan, in the later period. Violations of all these rules meant that one had resorted to illegitimate violence, which is strictly forbidden and is termed hiraba in Arabic. In modern parlance, hiraba may be considered to be the equivalent of terrorism, whose perpetrators show callous disregard for the sanctity of civilian life and instill widespread fear among the general population. So I think I'm going to leave it there and invite your comments during the Q&A session. Thank you.
Thank you so much, Dr. Afsarudin. Dr. Al-Dawoodi, we'll turn to you now. You actually did write the book on Islamic law of armed conflict. For those in our audience who are not familiar with its provisions and applications, if you could expand upon what's been discussed so far, and perhaps a comparison between Islamic law of armed conflict and Western IHL and ICL.
Thank you so much, Sarah, for organizing this webinar. And it's always a great pleasure to listen and to read to Professor Afsaruddin and Professor Zuli. As both of you in your introduction, Sarah, and in your presentation, Professor Afsaruddin, you saved me a lot of time because you already indicated to the relevance and the history of the development of the Islamic law of armed conflict. As Professor Afsaruddin says, it goes back to the 7th century and particularly to the first major battle in the early Islamic era, the Battle of Badr in March 624. And since then, classical Muslim jurists developed a legal body or a legal framework that regulates the use of force in armed conflicts. Professor Afsaruddin focused on the Islamic jus ad bellum part, and I will try to focus here on the Islamic jus in bello part of the Islamic law of war. And as we speak now, in fact, 70% of the ICRC operations and budget are focused in the Muslim world. Only in Africa, 41% of the ICRC budget are focused in Africa, and 30% in the Near and Middle East region, and 16% in Asia and the Pacific. And this shows the relevance of the using Islam as a source of reference in order to ensure compliance for IHL principles. The case is not only with the ICRC, the relevance of Islamic law, but also for the UNHCR. As we speak now, 57% of UNHCR refugees come from only 3 countries: Syria, Afghanistan, and the south of the Sudan. And it is unrealistic to ignore the role Islamic law could play in such contexts. So what I will try to do in these 8-9 minutes is to take you into a kind of intellectual legal journey that goes back to the 7th century and address a number of specific 8 Islamic principles regulating the use of force in armed conflicts in order to show that in specific circumstances, Islamic law could be used to save lives and protect civilians. If we go back to the early available legal literature, Islamic legal literature that goes back to the 7th, 8th, 9th century onwards, we will see under the chapters of Al-Siyar in the legal compendia of the Hanafi school of law, or under the chapter of Jihad for the rest of the 4 Sunni schools of Islamic law, detailed the regulations regulating the use of force. And more or less, they start with the same order that I will refer to now. All these chapters always discuss the issue of the protection of civilians and non-combatants. And as Professor Afsaruddin shows, there are specific categories that cannot be targeted under Islamic law that even were mentioned by name in the hadith of Prophet Muhammad, which include women, children, the aged, the clergy, and a category called in Arabic usafa, which refers to slaves or contractors, i.e. anyone that is contracted by the enemy to do services in the battlefield, but they do not engage in fighting. Based on understanding the rationale of this prohibition, classical Muslim Jews throughout history extended the list of these protected category to include anyone that does not engage in hostility. But this also does not mean that there are clear-cut rules, clear-cut categories that cannot be targeted, because classical Muslim Jews also deliberated the issue of the indirect participation in hostilities, and here they have varying opinions. But before I will go into this, I would like also to pinpoint here that also classical Muslim jurists knew the distinction between international armed conflicts and non-international armed conflicts. What I'm focusing here now is about international armed conflicts. So the first principle is the protection of civilians and non-combatants, and we have these specific categories where if used now could save many lives in the ongoing armed conflicts. There are a lot of details that could be talked about now. What if women engage in hostilities? How can we define a child? What is the minimum age limit of recruitment? And the issue of a child soldier? All these are issues that, if we use Islamic law, could save people's lives in this case. Also, by using the Islamic tool of analogy, if we include those who are contracted by the enemy to do services in the battlefield, this would apply to humanitarian workers, to any kind of contractors that do not engage in fighting. And this again could save people's lives, because as you all may know, we have already lost the lives of colleagues and humanitarian aid workers in ongoing armed conflicts as we speak. Also, classical Muslim jurists discuss the prohibition of the use of indiscriminate weapons, and they refer to specific weapons in their war situations, including what they call mangonels or catapults, and poison or fire-tipped arrows, because of the indiscriminate effect these two kind of weapons could have. And they disagreed between those who totally prohibit such kind of weapons because they could lead to indiscriminate killing of civilians and non-combatants, and those who permit the use of them only in the case of military necessity, and if any casualties took place, it's only justified as a collateral damage. So this shows us that also there are certain restrictions on the use of weapons. The same applies also for the prohibition of indiscriminate attacks and the methods of warfare. And we see also two issues that are discussed in all the classical Islamic legal books. One is called al-bayat, which means night attacks or engaging and fighting against the enemy during the night, and al-tatarrus, which means human shield. What do they mean by human shield is here not taking the enemy as human shield, the civilians or prisoners of war, but shooting at the human shield in case if the enemy took their civilians or Muslim prisoners of war as human shield and shoot at the Muslim army at this case. Will it be allowed to shoot at the enemy in this case or not? So here in both cases, whether we are speaking about night attacks or shooting at the human shield, the main concern for the classical Muslim jurists here is the mere fact of not jeopardizing the lives of civilians and non-combatants. Here we find sometimes conflicting opinions, of course, and this is understandable, between those who give priority to the humanitarian concerns and those who give, of course, priority to the pragmatic concerns of winning the war. These kind of classical Islamic deliberations, which goes back to the 7th century, in fact, are being used as we speak now by certain armed carriers to justify their use of force that sometimes lead to fatalities among civilians by referring to the issue of night attacks and shooting at the tatarrus or human shield. As also referred, there is always a clear-cut rules about the protection of property in Islamic law, and there are a number of specific rules or instructions that was given by the Caliph Abu Bakr, who died 634, to his army commander, which includes do not cut fruit-bearing trees, do not destroy buildings, and so on and so forth, which shows also that unnecessary destruction of enemy property is prohibited in Islamic law. The fifth humanitarian principle is mutilation, and it is quite clear, and there are strict prohibitions given by Prophet Muhammad to denounce this mutilation as a sin and disgusting act. But the other issue that could be a bit problematic here relates to the treatment of prisoners of war. And here we need to distinguish between two different issues: treatment of prisoners of war during captivity and the Islamic position on the termination of captivity of prisoners of war. Regarding the treatment of prisoners of war during captivity, it's more or less in harmony with IHL principles. They ensure humane treatment of prisoners of war. They have the right to food, water, clothing, and humane treatment. And of course, it's prohibited to torture prisoners of war, even if Muslims seek to get military intelligence from them, as was clear in the instructions or the opinions of Anas ibn Malik, the founder of the second school of Sunni school of law. But when it comes to the Islamic position on the termination of captivity, classical Muslim jurists were confronted with different Quranic texts and also different precedents in early Islamic history. So facing these different precedents, the majority of them said that the position on the termination of captivity is left to the states to decide from these A, B, C, D list of rulings. And one of them includes execution of some or all of the prisoners of war. But the other group of Muslim jurists say, no, this is not the Islamic position because the Quran makes it clear that the position on the termination of hostility is to set them free or to set them free in exchange of prisoners of war, which means that execution of prisoners of war is not permitted according to Islamic law. Then it's a very important system or principle according to Islamic law called the Aman, which refers to two different things here, safe conduct and quota. When it comes to safe conduct, it means that any citizen of an enemy state can enter the Islamic territories if they seek Aman. And if we use the Aman system now, and it is actually being used by international humanitarian organizations to receive security guarantee to work in certain contexts where army carriers use Islamic law as their source of preference. So this gives protection to humanitarian organizations under Islamic law. Quota refers to if the enemy prisoners of war asks for quota, then they cannot be harmed. Because of time, and finally, when it comes to human dignity, these rules also ensure that the enemy are being treated humanely, whether they are dead or alive. And I'll give you some examples that relates to the dead body management. And this is an issue that I collaborate a lot with the forensic experts at the ICRC because they are confronted with many issues and challenges in the Muslim context, including, for example, quick burial, because in many societies, the families of the deceased wants to bury their dead as quickly as possible, but also collective burial and exhumation of human remains, autopsy, because also autopsy is something that is current in Islamic and Jewish faith. Also the issue of burial at sea and handling of the dead bodies of the opposite sex. These are a number of examples of contemporary issues that Islamic law could help a lot to ensure protection or to ensure human dignity. And in conclusion, we see here in the ICRC and many other international organizations that we face many operational challenges that facing these specific humanitarian principles in contemporary armed conflicts in the Muslim world as we speak. And addressing these challenges in a way that shows how humanitarian principles are shared across cultures and legal traditions, as you, Sarah, referred in your introduction, is in fact necessary to save human lives and alleviate human suffering. And it's a practical and pragmatic approach that we have to adapt to preserve even a bare minimum of humanity and armed conflicts. It's an approach that seeks not to just safeguard lives, but also human dignity, and we can use it through the Islamic law of armed conflict. I stop here and thank you.
Thank you, Dr. Al-Dawoodi. We're now going to turn to Dr. Zoli, who has written extensively on looking at Islamic law in the military context with armed conflict. And Dr. Zoli, would you share with us some of your work, your conclusions, and why this is so important when we look at military actions and Islamic law?
Yes, thank you very much, Sarah, for developing and designing this webinar. It's really a pleasure to talk with colleagues in this context and to have the chance to engage. I know what is a diverse audience. I thought I would share my slides just because I have a couple of graphics to help demonstrate some of these more contemporary issues. I'm going to shift our focus a little bit from the historical accounting that my colleagues just did a wonderful job providing a context for, and try to bring us into the contemporary moment and address how Islamic notions of humanitarian law are very much primed and agile in addressing contemporary complex conflicts. So I think it might be helpful to see those slides in the process. It looks like when I try to share them, Sarah, it says it's disabled. I don't know if for some reason if it's too difficult, I can just not share them and I can provide them to you later. And if you want to attach them for audience, that's fine too.
That would be helpful. I'm trying to figure out why it's not letting you share. But in the meantime, if you want to go ahead with your presentation, and then we can share them with participants afterwards.
Sure, absolutely no problem. So the overarching question that I'm trying to address is how and why Islamic law approaches apply to modern armed conflicts. Now, some of the answer to this question is implied in what my colleagues have already said, but thinking from a more contemporary perspective, there are two sort of sets of background knowledge that are necessary so that we can understand how how Islamic legal methodologies are applicable. One is the issue of how modern armed conflict itself has changed. And the second is how the international legal system, especially public international law, but also you can see it in international criminal law and the international state system in general, is under pressures right now, is under challenge right now. I won't say a lot about the role of the kind of contemporary challenges on the international state system and public international law and human rights law as well. I mean, I'm assuming that folks have a sense of some of these criticisms of public international law, that they understand this notion of the twilight of the so-called twilight, as Eric Bosner puts it, of human rights law. And I don't agree with those critiques, but it's an important indicator of the kind of time we're living in. But in the case of armed conflict, because it can be confusing, I do think it's worthwhile talking about the nature of armed conflict today. Many of us aren't aware that our dynamics of armed conflict are entirely different. We do not have a preponderance of international armed conflict, so state versus state or multiple state, World War I and II type conflict. We have instead a preponderance of intrastate conflict, non-international armed conflict, as Professor Al-Dawoodi mentioned. So that we see very irregular, complex conflicts and disputes. Lots of them are internal, civil wars predominate, irregular warfare and irregular gray zone type challenges with the prevalence of terrorism, for instance. And almost every state in the world faces some form of irregular conflict at some time in the last 2 decades. And actually the deaths from terrorist attacks alone have been on the rise in a peak period in the 1990s, but then there was a lull, but then after 2001, 9/11, they have been rising again, and they're not insignificant. So that landscape of international conflict, armed conflict, is quite different today. And it's that complexity that I think Islamic law is particularly well adapted to address. Okay, so in moving to the next part of my presentation, which addresses more squarely Islamic approaches to these issues, Both of my colleagues addressed the historical role and contribution of Islamic law and Sharia, the template building role that Islamic law plays in Pakistan Sarvanda, honoring contracts, developing contracts, the template building, relationship building role it plays in terms of being one of the first international legal corpus, for instance, and through trade and commerce, establishing how different states would relate to each other, and developing peace-oriented and conflict resolution mechanisms with the Prophet himself in some of his earliest agreements and conflict resolution arrangements with different groups. So I think those are, beautifully well covered. So the theme there, I think, though, is that Islamic law plays this kind of template building historical role in some of our foundational international legal norms, whether it's making and keeping contracts, whether it's developing rules and norms for international relations, whether it's coming up with locally implemented conflict resolution mechanisms and peacekeeping agreements, and whether it's creating larger international alliances for collaborative conflict resolution and collective action problem solving. Okay, so those are the areas that I think that my colleagues have already spoken to, but I just wanted to bring them out at a higher level of abstraction so you could see the themes there. I will say, and again, Professor Al-Jaloudi's work really addresses this on the IHL side, the humanitarian law or laws of armed conflict side for the Islamic tradition. There is also a way, and I think this is quite distinct from Islamic humanitarian law versus IHL, there's a way in which Islamic law is extremely local, custom, and praxis oriented. So those conflict norms that I mentioned that are in keeping with more general universal norms about protecting PWs, prisoners of war, or having protected persons who are not to be targeted in conflict, like women and children, religious authorities, elderly, and others. And actually, as Professor Afsarudin mentioned, also trees and crops and animals that are sustenance-oriented animals. So that whole area of law, while there are universal norms there about protected persons under Islamic law, they're very hardwired into local customary understanding. So I think one of the virtues of Islamic law in approaching questions of armed conflict is there's a very clear local context shaping role that it plays, which is quite distinctive from IHL more generally. So having said that about the kind of historical approach, I want to address two elements. One are Islamic law strengths and challenges in the contemporary context for dealing with conflict. And then two, just make some reflective thoughts about Islamic law lessons learned that we can see in terms of how specific states have addressed these issues and where they've faced challenges and where they've come up with solutions. Now, in saying all of this, I'm drawing on my own research, which I believe Sarah mentioned, but two essays in particular that I think, and two essays in particular that I think are helpful here. The first is The God Gap in International Affairs, Missing Cross-Cultural Conversations in International Humanitarian Law and Islamic Jurisprudence. And the second one is with my two colleagues, Sharif Bassiouni, who recently passed away, which is very sad for many of us, and Hamid Khan, called Justice in Post-Conflict Settings, Islamic Law and Muslim Communities as Stakeholders in Transition. So if you want to hear a more drilled down discussion of those issues, you can look to those two particular essays. But the reason I mention them is that the God Gap essay in particular showcases the way in which when we try to solve problems in international affairs, especially with a conflict resolution mindset, so often we ignore, bracket, or even silence religious-based norms or religious-based solutions to that process. And so I think Islamic law has, a kind of tried and true history and set of analytical resources to talk about the role of religious norms in international conflict resolution. So that's the kind of broader thesis or broader point there. In the case of the co-authored essay about justice in post-conflict settings, there are specific Sharia norms that have been, again, tried and true and used often, including criminal justice norms that are applicable in post-conflict settings that, again, we haven't, because of a kind of, I would say, even latent bias against using religious-based norms in international conflict resolution, we haven't often returned to these as potentially helpful resources, both analytical and practical, in addressing post-conflict reconstruction, which is a very, as many of us know who work in conflict studies, that moment directly after a conflict ends, directly after a war or a particular set of atrocities, for instance, ends, is a very vulnerable period for the stability of a community or the stability of a government or even a society. So it's in that very delicate, vulnerable moment where the use of some Islamic norms and values, especially if they're culturally relevant, is incredibly important and can be very reassuring to take that community or that society or that government into the next phase of stability after conflict. Okay. So I can just mention, I think I'm getting close to my time, but I can just mention a couple of elements inside Islamic legal traditions that will be sources of strength, but also have some aspects of challenges. And one way of thinking about this is that the strengths are also potential sites of challenge, right? I mean, it's kind of like opposite sides of the same coin. So to just give an example, the diversity of Islamic law and practice, the idea that there are over, 50 states who are practicing some form of Islamic law in their domestic and national legal systems and jurisdictions. There's quite a range of diversity. And again, Professor Al-Dawoodi does, really interesting work in trying to talk about the different legal schools of thought and tradition. And so that diversity is both a strength because you can have very locally specific applications of Islamic justice and Islamic informed solutions. But from a broader perspective, it can also be seen as a weakness because there's a lot of inchoateness and a lot of potential conflict over how a particular norm is prioritized in a given legal jurisdiction and how it should be applied in a given situation. And I remember being, fairly recently in Saudi Arabia and talking about this issue. And, governments are Muslim majority governments are often very critical of this, especially in fighting contemporary conflict dynamics like the issue of extremism and terrorism. They feel like if there were more of a centralized authority in the Islamic legal system, that it would be easier to apply some of these norms in situations that are very messy. So it's an interesting idea that diversity of interpretation and much cultural and societal variance in interpreting Islamic norms is both a strength and a weakness, right?
Dr. Zoli, thank you. I appreciate that. We're running close to the end here, but we want to try to get to as many questions as we can. So I'm going to open up for all of our panelists to jump in to what they think. We also have some questions that are directed to some of you, so we'll try to get to as many as possible. To start, Jordan is the only country in the Middle East and Gulf region that has joined the International Criminal Court. For any of you looking, as we've discussed today, about the role that the Islamic law of armed conflict plays, do you see more countries in the region joining the ICC, and why or why not? Who wants to jump on that one?
I can jump in, and I'm sure others have things to say as well. I have a slide that shows who's a state's member, and you can see the regional dynamics of that process, right? That in the Middle East and in Africa, North Africa especially, there are lots of governments who are saying that they're not going to choose to either go from a signatory to an actual states party, or they're not going to actually become a states party to the ICC and to the Rome Statute. I think part of the issue is that there's been a concern, especially in the global South, about bias in the ICC. There's a concern that certain governments and certain powerful states are form a bloc and tend to focus their kind of criminal justice scrutiny and penalties more on, in this case, African nations or certain global South nations. So I think there's a concern about bias and more powerful states forming a bloc and having a heightened scrutiny against not as powerful states. I also think there's a concern about religious norms and making fair and inclusive accommodations for different interpretations of some of our international criminal justice norms. So that's where I would start, at least.
We have a question for Dr. Afsaruddin. The attendee wants to ask about the status of the Medina Declaration and the last speak of Prophet Muhammad, peace be upon him, as a source of IHL, and whether these are binding upon Muslims.
I think by Medina Declaration, they mean the Constitution of Medina that was drawn up after the emigration to Medina from Mecca. Actually, the Constitution of Medina could be considered to have quite a bit of relevance, not necessarily in the direct resolution of armed conflicts, but in creating a multi-faith and multicultural community that can live together in peace despite religious differences. So the Constitution of Medina deliberately brought in the Meccan Muslims, of course, and the Medinan Muslims, but also the Jewish communities in Medina, and made them signatories to a common document that today in modern parlance we refer to as the Constitution, in which they had equal rights and duties, reciprocal rights and duties. And one of the duties they had in common was the defense of the Medinan polity if it were to be attacked. And this document actually has become quite important in recent discourses, particularly among liberal and modernist Muslims, as pointing the way forward to crafting such communities where it actually proclaims equal citizenship for members of a polity, not based on religion, but rather based on common interest and common defense. So I would agree that the Constitution of Medina can also be used as a source in the modern period to resolve differences, particularly religious-based differences.
Wonderful. Dr. Al-Dawoodi, we have a few questions regarding ICRC's work and what challenges the ICRC faces in your work on the ground in countries in IHL and Islamic law, as well as looking at, in spite of all of these provisions, how do you see them being implemented today?
Thank you. Thank you so much. In fact, ICRC faces lots of challenges, not necessarily in the Muslim context alone, but this is by virtue of 70% of the conflicts are taking place in the Muslim context. So it shows the priority or the importance of engaging on IHL and Islamic law. But at the same time, it might be also useful to say that at the same time, as we speak, also ICRC engages with other religions and other traditions and cultures, focusing more recently over the last 2 years on IHL and Buddhism, and also with other religions. I also need to give here the semile of, just to clarify why ICRC is engaging on other legal traditions. IHL is the mandate of the ICRC, but the engagement on Islamic law is purely pragmatic and practical and innovative approach. Let's assume that you are based in the United States. And I see some of you travel frequently to the Middle East. If you go with your cell phone and your service provider does not give you roaming access in the Middle East, when you go to the Middle East, your cell phone will not be working. Yes? So let's say that your service provider gives you roaming service to work in everywhere in the world. And this is the case with the Geneva Conventions. All the world has accepted the IHL, the Geneva Conventions, as the legal regime governing the armed conflicts as we speak now. And when we engage on IHL and Islamic law, in this case, actually, we are universalizing IHL principles by saying that it is not in contradiction with other legal systems and traditions. But in specific cases and specific armed conflicts, your cell phone could have no roaming service. It is not functioning. And in specific armed conflicts and with the specific non-state armed groups, they do not acknowledge IHL. They do not acknowledge any other legal system or tradition except Sharia or Islamic law. So now you are left with a situation. What to do? Either to engage with them on their own source of reference in order to achieve the same objectives of IHL, or to leave the vulnerable people left to violations of IHL. In the very brief introduction that I gave, we showed that IHL is more or less in harmony with the Islamic law of armed conflict. And in fact, many Muslims, whether Islamic law professors or non-state armed groups, believe that in some cases, Islamic law of armed conflict is more detailed and humane than the modern IHL regime. So this is not to undermine the universality of IHL, but to universalize IHL principles by showing that it is in fact in harmony with other legal systems and traditions, but also with local customs and norms. Whether we are speaking in Somalia or we are speaking in Papua New Guinea, these people have developed or have known some rules regulating their use of force that goes back hundreds and hundreds of years ago. And apart from this, in fact, IHL will not be respected. And in fact, it is still unknown in many parts of the world. And the same applies, if I go back to the previous question, the same applies with international criminal justice. We have to show that we share common values and common principles regardless of the brand.
Wonderful. A question for any of you to chime in on. Looking at the differences between IHL and Islamic law of armed conflict, what, if each of you would want to chime in on one or two things that you think modern IHL and ICL could learn from and adapt from what's contained within Islamic law?
I'm happy to, I don't want to dominate. I mean, one obvious, and I know this is in both of your work, so one obvious element is legal innovation. It tends to, Islamic law has historically in the contemporary moment tended to prioritize legal innovation, usually on a case-by-case basis. So that's something that, you know, we all know in the case of the Geneva Conventions that, yes, there has been innovation, of course, with the additional protocols, but it's hard to do, very hard to do legal innovation in the case of, you know, IHL and the Geneva Conventions. It's hard to get all the states together to agree and be willing to try to do an addition or an addendum. Whereas Islamic law, you have at the local jurist level, people can begin to create interpretations that allow for innovation.
If I may add to this, and thank you so much for saying this, because this goes against one of the main misconceptions that relates to Islamic law. When you speak about Islamic law, people think that it is divine, it's fixed, and unchangeable. And thank you so much for referring to this element of innovation, but also flexibility, because these rules are developed by independent individual Muslim jurists who have different interpretations, which could suit one part of the world different from another. Islamic rules developed in Morocco could suit Moroccans, but not Indonesians and Somalians, and so on and so forth. So the flexibility is one thing, but the major point here is compliance. Because one of the characteristics of Islamic law, it is self-imposed. So once Muslims believe in that this is Islamic, they voluntarily come to comply with it, which is the main advantage that you cannot find in IHL, for example. As we speak, we see the violations from states who are signatories to the Geneva Conventions. And at the same time, even if you speak about non-state armed groups, some non-state armed groups develop their own codes of conduct based on Islamic law. Why? Because they want to respect Islamic law. So this is a key issue, a key point here, compliance, which I think we as the international community are not using it enough. And then we are losing a lot.
So just to quickly add to that, I basically agree with everything that was said. I think the legal innovation is actually a very important aspect of Islamic law. But I think, to go back to a point that was made earlier by either one of my two colleagues here, that the inbuilt flexibility and the respect for local norms, we tend to forget what a large part of Islamic law is actually based on custom, right?
Exactly.
And we tend to leave that out. We, always say, of course, the Quran and the Hadith or the Sunnah are the two very important sources of Islamic law, as there must be. But customary law was also a very important aspect of the development of Islamic law. So we can use that information to great advantage, I think, in the modern period. When we try to resolve armed conflictual situations on the ground, we should take into consideration, or practitioners of Islamic law should take into consideration the different norms, cultural attitudes that exist on the ground. And there's plenty of historical precedent for that. Realpolitik was also a very important source for the crafting of Islamic law, as it must be for any legal system. So some of the decisions that were made in the classical period are not necessarily applicable to our modern world, but we have the foundational principles and the legal norms with which to work with and craft new responses on the ground in conflictual situations. I think that is one of the greatest strengths of Islamic international law.
Unfortunately, we have reached the end of our time today. These conferences, I think, could be half-day or all-day seminars. We have a number of questions that went unanswered. I'd like to apologize to our attendees, but it gives us a lot of material and ideas to continue. We can think of this as Islamic Law of Armed Conflict 101 and continue these sessions in the future. I hope all of you who are watching can give a huge thanks to our wonderful panelists today for their insights. Please look them up online, look at their materials. Books are available at most online booksellers. And thank you to all of my panelists, and wish all of you a safe and healthy rest of this strange time we find ourselves in. And we look forward to you joining us to more future webinars. Thank you to all.